Daniel Findling with Findling Law and thedivorceguy.com. And in this webinar, we're going to discuss custody modification in Michigan, how to change custody. Let's get started. Let's start with the high-level approach, sort of a big picture idea of what's involved in a custody modification. I've broken this down into 4 key components. Maybe we'll call it the process of modifying custody in Michigan. The first, are we really trying to modify custody or parenting time? The second, is there proper cause or change of circumstance? Third, is there the existence of an established custodial environment? And fourth, we conduct a best interest analysis. Let's take a closer look into each of these 4 components. Well, the first step in this process is, are we trying to modify custody or parenting time? Let's take a closer look at what I mean by that. All right, you'll see on the screen that there's legal custody, physical custody, and parenting time. Legal custody describes major or important decisions regarding the welfare of the child, such as health care. Now, in virtually every case, there's an award of joint legal custody, where the parties will share equally in these decisions. Under certain circumstances, the parties are in such high conflict that it's impossible to agree on anything. And each and every time a simple medical decision regarding the minor child is at issue, you're in court. Now, in that circumstance, it may be necessary, or you may want simply to modify legal custody so that one parent has sole legal custody and does not have to consult with the other parent regarding these important decisions. Physical custody deals with simply which parent does the child spend the majority of parenting time. If one parent has 5 overnights a week and the other parent has 2 overnights a week, or 4 overnights and 3 overnights, the individual with the majority of the parenting time would be the physical custodian. Now, sometimes this term physical custody isn't used anymore, maybe for political correctness purposes. Sometimes it's not even used at all. There's simply a parenting time schedule. However, if one parent has the majority of parenting time, they're considered the physical custodian or the primary custodial parent. And parenting time describes the frequency by which a child spends with each parent. Well, if Monday and Tuesdays are with mom and Wednesdays and Thursdays are with dad, and maybe the parties alternate weekends, alternate the holidays and the school breaks, they would have equal parenting time. But which overnights with which parent is what we describe parenting time. Now, the legal test to make that determination, are we trying to modify custody or are we trying to modify parenting time, is called the Established Custodial Environment. And we're going to talk about the Established Custodial Environment in just a moment. But in really basic terms, if one parent has the majority of the parenting time, they typically also have an established custodial environment with that child. All right. Now, when talking about the law, it's easy to get caught in the weeds and lose sight of the forest. So before we examine an established custodial environment in more detail, let's take a few steps back. Before you can go to court and ask that custody be modified, you have to show that there's been a change of circumstance or proper cause since the entry of the last order. You cannot just leave court with a ruling that you don't like on custody or parenting time and then show up the next day with a motion or a request to modify it one more time. And the protection is proper cause or change of circumstance that prohibits an individual from filing a motion unless things have changed. The leading case on this is called Vadvarka versus Grassemeyer, which really defines for us what proper cause or change of circumstance means. Now, with proper cause, in order to revisit a custody order, whether it's legal custody or physical custody, you must prove by more likely than not what we call the preponderance of the evidence that since the entry of the last order, there's been proper cause to have such a magnitude that it really has a significant effect on the child's well-being. And you do that by looking at the 12 best interest factors. Whereas a change of circumstance is a little bit broader. Anything that has materially changed, a change since the entry of the last order that is significant and that has an effect on the child, would be a proper change of circumstance. Now, unless you can show proper cause or change of circumstance, the judge will stop you right there and the motion will be denied. Now, with parenting time, it's a little easier. If you're modifying parenting time, the seminal case is Shade versus Wright. Normal life changes such as attending new school, just getting older, is enough to modify parenting time. Even something as simple as, I'm now remarried and my spouse's weekends are the opposite of my weekend, so I'd like to alternate the weekends. That modification of parenting time. I've certainly handled that case before. And Shade versus Wright says that the threshold requirement to modify parenting time is significantly lower than to modify custody, whether it's legal or physical custody. Well, what rises to proper cause or change of circumstance? What is a significant change that has an effect on the child's well-being? What is proper cause? Well, some examples from experience include a child is no longer attending school, maybe substantial absences because a parent is unable or unwilling to drive that child to school or even to get them to school. That has been held to be both proper cause or change of circumstance to modify custody. From a legal custody standpoint, when the parties can agree on nothing, I had a vaccination case where one party was an anti-vaxxer and another party was a vaxxer, and every time the court ordered that the child would be vaccinated, the other party would interfere. And in that case, that was proper cause or change of circumstance for the court to revisit legal custody. Physical abuse, if the child's been exposed to physical abuse, that's clearly proper cause or change of circumstance to modify custody. If a child is no longer getting along with the parent, that is, maybe they're 14 or 15 and they're belligerent and non-responsive and really just causing a hard time because of the other parent's behavior or otherwise, that may be proper cause or change of circumstance to modify custody. I think you get the point. In order to modify custody, there has to be something big that's changed since the entry of the last order. If we're just modifying parenting time, it doesn't have to be that big. But remember, parenting time modification becomes a custody modification if we're changing who has the majority of overnights. So if parenting time was equal, moving parenting time from equal parenting time where one parent, the request to modify parenting time would result in the other parent not having equal parenting time, that's a change of custody and the higher threshold applies. On the other hand, if you're just trying to go from 3 overnights a week to 2 overnights a week, that's a modification of parenting time. And the lower threshold under Shade versus Wright applies. So before you can go to court and ask that custody or parenting time be modified, you have to remember there must be proper cause or change of circumstance since the entry of the last order. Once the threshold requirement of proper cause or change of circumstance has been met, in modifying a custody arrangement, whether it's legal custody or physical custody, the first step is to determine, is there an established custodial environment? Because if there is an established custodial environment, it affects the burden of proof or how much evidence is required to modify custody. So what is an established custodial environment? It's described under statute that if over an appreciable period of time, the child looks to one parent for guidance, discipline, or the necessities of life and parental comfort. To which parent does the child look to for the regular necessities of life over an appreciable period of time? Now, there can be an established custodial environment with both parents or one parent. And the reason this is important is if there is an established custodial environment, it changes the burden of proof. Let's see how. The reason an established custodial environment is so important is it tells us which burden of proof do we apply. In a child custody case, whether it's modification of legal custody or modification of physical custody, or with which parent the child spends the majority of parenting time, there can be two burdens of proof: preponderance of the evidence and clear and convincing evidence. All right, well, there are a lot of burdens of proof under the law. On one end of the spectrum, the lowest burden of proof that we have is preponderance of the evidence. So it's very easy under a preponderance of the evidence standard, whereas to modify custody, whereas it'd be much more difficult under a clear and convincing standard. Preponderance of the evidence really means more likely than not. Clear and convincing evidence means that a court will not modify an existing custody order unless there's clear and convincing evidence to do so. Now, it's hard to put a percentage on that. Does that mean 90% certain, 80% certain? Well, no one really knows, but it must be clear and convincing. Now, the highest burden of proof under Michigan law is beyond a reasonable doubt. We will not incarcerate an individual or convict them of a crime unless it's been proven beyond a reasonable doubt. Any doubt, and you must acquit. That's not the case with clear and convincing evidence. There can be some doubt, but just not a lot. So if there's an established custodial environment with one parent or both parents, a court will not modify custody unless you can show by clear and convincing evidence that it's in the best interest of the child to do so. Whereas if there's not an established custodial environment, the rule is preponderance of the evidence. And that even is the same rule for modification of parenting time. Why? Because you're not modifying the established custodial environment. While the established custodial environment tells us what burden of proof that we must apply when trying to modify custody, the best interest analysis tells us what we have to prove. Now, with the established custodial environment, we have to prove either by clear and convincing evidence or preponderance of the evidence, and the best interest analysis tells us what we need to prove. Now, there are 12 child custody factors, and I spend a tremendous amount of time in the child custody video that accompanies this as well, and you can look at it on our website or on YouTube. And it describes each and every one of these factors in detail. But when seeking to modify custody, if you want to change it, you have to show either by preponderance of the evidence or clear and convincing evidence that 12 factors has changed since the entry of the last custody order. And if you do so, you win, and custody is modified. Now, we've covered a lot of information, and I'm going to bring it back to simple again. There are 4 steps in any custody modification request. First, are we trying to modify custody or parenting time? It's important because if we're trying to modify parenting time, it's a lot easier. Shade versus right. Normal life changes is enough of a change of circumstance or proper cause. Because the threshold says we're not going to modify an existing custody order, number 2, unless there's proper cause or change of circumstance. And if there is, we have to ask ourselves, is there an established custodial environment that sets the burden of proof? And then we can do our best interest analysis to see how the evidence applies to the best interest factors. It's important to be prepared. So often people show up to modify custody, and lawyers show up sometimes, and just argue a single issue. But proper preparation and application of the law confines the court to rule in your favor. Preparing each and every one of these 4 steps can help you be successful in your request to modify custody or even parenting time. I'm Daniel Findling with Findling Law and thedivorceguy.com. I want to thank you for your time. It's inevitable that you may have questions. If you do, I provided my phone number below and of course my email. You're always welcome to call or email me. Visit us on thedivorceguy.com. Now, we've prepared these videos for a number of years now and they've received hundreds of thousands of views. We do so as a courtesy to our clients in the legal profession. Thank you once again, and if you need legal assistance, let it be our privilege to help you.